In this video, we'll finish our look at the UCC's Statute of Frauds by examining the various exceptions to the statute's writing requirement. Even if there is no sufficient writing, there are various exceptions that would allow for the enforcement of an oral agreement despite the party's non-compliance with the writing requirement of the statute. Stated differently, there are various exceptions to the writing requirement of 201. These exceptions reflect the judicial and legislative recognition that the statute of frauds is a double-edged sword. The statute may do as much harm as good. It does good by preventing fraud, by preventing the enforcement of contracts that were never actually made, that were the product of one party's fraud or perjury. But at the same time, the statute may do harm by enabling fraud, by enabling one party to falsely deny the existence of a contract that was actually made but for which there is no sufficient writing. This latter concern provides the rationale for the various exceptions. Where there is some other evidentiary basis other than the statutorily required writing to believe that a contract was actually made. That evidence allays the concern that the alleged contract is a product of fraud, justifying the enforcement of the contract despite the absence of a sufficient writing memorializing the parties' agreement. Note again, it's unnecessary to consider these exceptions if we have a contract that is not subject to the statute of frauds, or if we have a contract that is subject to the statute of frauds, but for which we do have a sufficient writing. There are four exceptions to the statute of frauds writing requirement that are codified in Article 2. The first of which is by far the most complex: the merchants must read their mail rule. It's codified in subsection 2 of 201, and it provides as follows. Between merchants, if within a reasonable time a record in confirmation of the contract and sufficient against the sender is received, and the party receiving it has reason to know of its contents, it satisfies the requirements of subsection 1 against the party unless a record containing notice of objection to its contents is given within 10 days after it is received. Stated differently, in a transaction between merchants, where one merchant receives written confirmation of the oral contract from the other merchant within a reasonable time after the oral contract is made, that written confirmation satisfies the writing requirement of subsection 1, thus barring the receiving merchant from raising the statute of frauds as a defense, but only if the written confirmation is itself sufficient against the sender. The confirmation satisfies the writing requirement of subsection 1 unless the receiving merchant objects to the written confirmation within 10 days of receiving it. Note two things here. First, this exception only applies to transactions between merchants. The exception is only available when both parties, buyer and seller, qualify as merchants. Thus, under this exception, merchants must read only the mail they receive from other merchants, not from non-merchants. Who is a merchant? Recall the definition of merchant from the last module. The basic definition that we can use for now is someone who deals in or otherwise has expertise in the type of goods or business involved. Comment 2 to Section 104 provides some further guidance, and it suggests the meaning is flexible depending on the context in which the term merchant is used in the UCC. Specifically, Comment 2 says that the special provisions as to merchants dealing with the statute of frauds, firm offers, confirmatory memoranda, and modification rest on normal business practices which are or ought to be typical of and familiar to any person in business. For purposes of these sections, almost every person in business would therefore be deemed a merchant. This comment specifically indicates that for the purposes of 201 subsection 2, almost every person in business would qualify as a merchant. Second, the written confirmation will only satisfy the writing requirement if the confirmation would have been sufficient against the sending merchant. What does it mean to be sufficient against the sender? The written confirmation must be sufficient to satisfy the requirements of subsection 1 if the sender were the party invoking the statute of frauds as a defense. That is, if the sender were the party against whom enforcement was sought. What kind of writing would satisfy subsection 1 if the sender were the party against whom enforcement is sought? Well, we need only look to the elements of subsection 1. The writing must be signed by the sender and sufficiently indicate that a contract was formed and indicate a quantity. Again, the policy rationale behind this exception is that contemporaneous writing confirming the existence of an oral contract, even if unsigned by the recipient, that is, the party against whom enforcement is sought, provides a reliable evidentiary basis to believe an actual contract was made, especially if the recipient fails to object to it. Merchants, in particular, are presumed to be attentive to their business correspondences. And if a merchant fails to object to a written confirmation of a contract, it is likely because that contract was in fact made. There are three other exceptions that are found in subsection 3 of 201: the specially manufactured goods exception, the admissions exception, and the part performance exceptions. All of these exceptions are more straightforward than the merchant's exception. Still, the one thing that all of these exceptions have in common with the merchant's exception is that they all provide some alternative evidentiary basis to believe an agreement was actually made, to allay the concern that the alleged contract is a product of the plaintiff's fraud or perjury. That evidentiary basis provides a reason to enforce the oral contract despite the party's non-compliance with the writing requirement of the statute. Let's look at these three exceptions more closely. First, the specially manufactured goods exception is codified in subsection 3A. To paraphrase that subsection, it says that a contract is enforceable despite the absence of a sufficient writing if, first, the goods are specially manufactured for the buyer and not suitable for sale to others in the ordinary course of the seller's business, and second, before receiving notice of the buyer's repudiation, the seller has substantially begun manufacturing the goods or made substantial commitments for the procurement of the goods. The rationale behind this exception is that the seller's actions to manufacture goods that are specially suited for a buyer who is now asserting no contract exists and that are not otherwise sellable by the seller to other buyers, those actions themselves evidence that a contract for those goods must have been made between the buyer and the seller, because there is no other likely explanation for the seller's action other than the fact that there must have been a contract between the seller and the buyer. The second exception, the admissions exception, is itself rather intuitive. If the party against whom enforcement is sought, that is, the party asserting the statute of frauds as a defense, has admitted in court, that is, in pleadings, testimony, or otherwise, that a contract was in fact made, then the contract is enforceable despite the absence of sufficient writing that satisfies the statute. Again, the rationale is that if the party has admitted to the existence of the oral agreement, that it allays the concern that the agreement is the product of the other party's fraud or perjury. Finally, the part performance exception is similar to the specially manufactured goods exception. The idea is that one party's conduct is itself inexplicable unless there was in fact some oral contract between the parties. The part performance exception applies in favor of the buyer where the seller has already accepted payment for the goods, or in favor of the seller where the buyer has already received and accepted the goods. In each case, the party's action in performance of an apparent transaction is an overt indication or admission that a contract has been made. The party's conduct provides an evidentiary basis to believe that the parties had actually agreed to some deal, even though there is no written evidence of that agreement. Importantly, Comment 2 to 201 provides that a transaction can be enforced only up to the amount of the goods received or the amount of payment accepted. There is one final exception to the statute of frauds, one that is not codified in the UCC, but that is recognized by some jurisdictions, the promissory estoppel exception. You likely remember promissory estoppel from your study of the common law of contracts. The Eighth Circuit's decision in Casazza versus Kaiser provides a pretty standard definition of the doctrine. Under promissory estoppel, a promise which is expected to induce definite action by the promisee and does induce the action is binding if injustice can be avoided only by enforcing the promise. Breaking it down into its basic elements, promissory estoppel makes an otherwise unenforceable promise enforceable against the promisor if the promise is reasonably expected to induce reliance, does in fact induce reliance, and injustice can only be avoided through the enforcement of the promise. In its original form, the promissory estoppel doctrine used detrimental reliance to substitute for the consideration requirement that is imposed on all contracts under the common law. Over the years, however, some courts have also recognized the doctrine as an exception to the statute of frauds, concluding that the policy of promissory estoppel, that is to protect the justified reliance of a party, outweighs the policy of the statute of frauds, to prevent the enforcement of fraudulent contracts that are the product of one party's perjury. Note that the promissory estoppel exception is different than the part performance exception that is codified in the statute. Under the part performance exception, in reliance on the oral agreement, the plaintiff took actions to perform its obligations. And the fact that party took those actions is itself evidence that a contract must have been made, which addresses the primary concern of the statute of frauds, which is to prevent frauds. The reliance in that case, that is the performance of the contract, itself serves the evidentiary function that the statute's writing requirement aims to fulfill. In contrast, under promissory estoppel, in reliance on an oral agreement, the plaintiff took other actions unrelated to its performance obligations under the alleged oral agreement. Note that this theory is controversial. Not all jurisdictions have accepted promissory estoppel as an exception to the statute of frauds. The concern is that if promissory estoppel is recognized as an exception to the statute of frauds, that would render the statute of frauds worthless, meaningless, or nugatory. Courts that do recognize promissory estoppel as an exception apply the promissory estoppel doctrine more exactingly and sparingly, either requiring that the promise that was relied upon was the specific promise by the defendant that the party's oral agreement would be reduced to writing, or more commonly, to require some heightened form of reliance on the part of the plaintiff. It's not enough that the parties seeking to enforce the oral agreement relied to their detriment. Rather, the reliance must give the court reason to believe that the alleged oral agreement was not the product of perjury. The reliance itself must evidence existence of a contract, even if the reliance did not directly go toward performance of the contract itself. Stated differently, the reliance itself must satisfy the evidentiary function required by the statute to allay the concern of fraud. So to summarize, in this video, we concluded our look at the statute of frauds as codified under the UCC, framing our discussion on the methodology that you should apply to every statute of frauds issue. Is the agreement one that is subject to the statute of frauds? If so, is there a writing or writings sufficient to satisfy the writing requirement of the statute? And if not, is there an applicable exception that would allow for the enforcement of the oral agreement despite the party's non-compliance with the writing requirement of the statute? In the next video, we'll look at the other defense to enforceability that is codified into the UCC, the doctrine of unconscionability.